The purpose of the lawsuit is to help these ministers, this county commissioner, understand how the Obergefell decision applies to the state marriage license laws. The Supreme Court held that marriage license laws are invalid if they exclude same-sex couples from marriage, and our statute says that the only persons who can get a marriage license are a male and a female, which would seem to say then our law is invalid, in which case this minister and the county commissioner who have performed marriages, may perform future marriages, want to know, are the marriages that we're officiating even valid, because the license itself that authorizes us to marry people is not valid. This case, this lawsuit, is really not about whether the Supreme Court can review a law by a state and declare it constitutional or unconstitutional, but it's about the principle: can a court declare a law invalid as violating the Constitution and then turn around in the same decision and then essentially enact a new state law to replace the one that the court has said invalid? Everybody learned in 8th grade civics classes that courts can't pass statutes. Only legislative bodies can pass statutes. And the Supreme Court appears to have passed a statute for the state that the state has not authorized. The Tennessee Constitution says that only the General Assembly can prescribe the duties of the clerk. So when the court says the law is invalid, okay, fine, you can say that. But you cannot prescribe a new statute to replace the one that you said was invalid. This is a critical case, not just about same-sex marriage, but about the whole principle of federalism and the limited powers of courts to enact new laws for states. And if we allow the Supreme Court to start ruling laws invalid and then saying, and here is your new law, then we essentially have converted the Supreme Court into a legislative body to replace the members of Congress and the members of our state legislature.